Let's examine constitutional distribution of authority. By distributing some authority to the national government and different authority to the state governments, the Constitution creates the dual sovereignty that defines the U.S. federal system. The Constitution specifically lists the several matters over which the national government has ultimate authority, and it applies additional national authority. The Constitution spells out just a few matters over which the state governments have authority. Part of the reason there is a lack of constitutional detail on state authority is that at the time the Constitution's drafting, the state expected to retain their authority, except for matters that, by way of the Constitution, they agreed to turn over to the newly created national government. To fulfill their responsibilities to their citizens, both the national and the state governments have the authority to engage in the functions inherent to all sovereign governments. This authority extends to the concurrent powers, the first topic of this section. To function, sovereign governments need the authority to make policy, raise money, establish courts to interpret policy when a conflict arises about its meaning, and implement policy. These authorities are recognized as inherent to all governments. They are defining characteristics of governments. In the U.S. federal system, we designate these inherent governing functions as the concurrent powers because the national and the state governments hold these powers jointly and each can use them at the same time. For example, the national and state governments make their own public policies, raise their own revenues, and spend those revenues to implement their policies. State governments delegate these authorities in limited ways to the local governments they create so that they can function as governments. In addition to the inherent governing powers that the national and state governments hold concurrently, in the federal system of dual sovereignty, the national government and the state governments have sovereignty over different matters. The Constitution distributes powers that are 1. Enumerated, or specifically listed, and 2. Implied for the national government's three branches, legislative, executive, and judicial. For example, Article 1 of the Constitution enumerates or lists, make sure that you know those are synonyms, the matters over which Congress holds the authority to make laws, including interstate and foreign commerce, the system of money, general welfare, and national defense. These matters are enumerated powers of the national government. The Constitution also gives implied powers, that is, powers that are not explicitly described but may be interpreted to be necessary to fulfill the enumerated powers. Congress specifically receives implied powers through the Constitution's Necessary and Proper Clause, sometimes called the Elastic Clause because the national government uses this passage to stretch its enumerated authority. Make sure you can make that distinction. The Necessary and Proper Clause states that Congress has the power to make all laws which shall be necessary and proper for carrying out its enumerated powers. Article 2 and 3 of the Constitution also enumerate powers of the national government. Article 2 delegates to the President the authority to ensure the proper implementation of national laws and, with the advice and consent of the U.S. Senate, the authority to make treaties with foreign nations and to appoint foreign ambassadors. With respect to the U.S. Supreme Court and the lower federal courts, Article 3 enumerates jurisdiction over legal cases involving constitutional issues, national legislation, and treaties. The jurisdiction of the Supreme Court also extends to disagreements between two or more state governments, as well as to conflicts between citizens from different states. The country's founders obviously anticipated disagreements over the interpretation of constitutional language and prepared for them by creating the Supreme Court. The court has mostly supported the national government when states, citizens, or interest groups have challenged Congress's use of the Necessary and Proper Clause to take on new responsibilities beyond its enumerated or listed powers. Unless the Supreme Court finds a national law to be outside of the enumerated or implied powers, that law is constitutional and hence the supreme law of the land as defined by the Supremacy Clause in Article 6 of the Constitution. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. That was from Article 6. State and local governments are therefore obligated to comply with national laws that implement national enumerated and implied powers, as well as with treaties, including treaties with Native American nations. Throughout U.S. history, the national government has signed treaties with Native American nations, which are legally viewed as sovereign foreign nations. As with all treaties, treaties with Native American nations are supreme law with which the national government and state and local governments must comply. The core issue in the majority of these treaties is the provision of the land, or reservations, on which the native peoples would resettle after non-Indians took their lands during the 18th and 19th centuries. Today, the federal government recognizes more than 550 Indian tribes. Although most Native Americans no longer live on reservations, most Native people have moved to cities, approximately 300 reservations remain in 34 states. If you ever travel up north towards the Finger Lakes region, there are a lot of signs for backlash against the sovereign nations. So that is definitely still a relevant conflict. Even though Indian reservations lie within state borders, national treaties and national laws, not state or local laws, apply to the reservation population and lands. State and local laws, including laws having to do with taxes, crime, and the environment, are unenforceable on reservations, which is one of the reasons why people go there to buy cigarettes and gas, because it's cheaper. Moreover, Native American treaty rights to hunt, fish, and gather on reservations and on public lands supersede national, state, and local environment regulations. With the exception of Native American reservations, state governments are sovereign within their state borders over matters the Constitution distributes to them all. What are the matters that fall within state sovereignty? The Constitution specifies only a few state powers. It provides the states with a role in national politics and gives them the final say on formally amending the U.S. Constitution. One reason for the lack of constitutional specificity regarding state authority is that the state governments were already functioning when the states ratified the Constitution. Other than those responsibilities that the states agreed to delegate to the newly created federal governments through their ratification of the Constitution, the states expected to retain their sovereignty over all the day-to-day matters internal to their borders that they were already handling. Yet the original Constitution did not speak of this sovereignty explicitly. The state's powers enumerated in the Constitution gives the state a distinct voice in the composition and priorities of the national government. Members of Congress are elected by voters in their home state, in the case of senators, or their home district, in the case of representatives in the House. Voters also participate in the election of their state's electoral college electors, who vote for the president and the vice president on behalf of their state. Overall, state voters expect that the officials whom they elect to the national government will carefully consider their concerns when creating national policy. This is representative government in action. In addition to establishing the various electoral procedures that give voice to state interests in the national policy-making process, the Constitution creates a formal means by which the states can ensure that their constitutional authority is not changed or eliminated without their approval. Specifically, the Constitution stipulates that 3/4 of the states, through votes in either their state legislatures or special conventions, must ratify amendments to the Constitution. By having the final say in whether the supreme law of the land will be changed through the passage of amendments, the states can protect their constitutional powers. Indeed, they did just that when they ratified the 10th Amendment in 1791. The Constitution's extremely limited attention to state authority caused concern among citizens of the early American Republic. Many people feared that the new national government would meddle in matters for which states had been responsible, in that way compromising state sovereignty. Citizens were also deeply concerned about their freedoms, corresponding to the protections listed in each state's constitutional Bill of Rights. The states ratified the Bill of Rights, the first 10 amendments to the U.S. Constitution, in response to those concerns. The 10th Amendment asserts that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states, respectfully, or to the people. These reserved powers clause of the 10th Amendment acknowledged the domestic matters over which the states had exercised authority since the ratification of their own constitutions. These matters included the ordinary daily affairs of the people: birth, death, marriage, intrastate business, commerce, crime, health, morals, and safety. The states' reserved powers to protect the health, safety, lives, and property of their citizens are referred to as their police powers. It was over these domestic matters, internal to each state, that the states retained sovereignty, according to the 10th Amendment. In addition, state courts retain sovereignty over legal cases that involve their state's constitution and laws. The 10th Amendment's affirmation of state sovereignty is brief and vague, and the Supreme Court continues to this day to resolve conflicts over its interpretation. New cases leading to fresh interpretations come before the court when state governments challenge national laws that the states deem infringe on their reserved powers, but the national government claims fulfill its enumerated powers. New interpretations by the court also arise when the national governments or citizens challenge the constitutionality of a state or local government action. Citizens, local governments, state governments, and the national government persistently ask the courts to resolve constitutional conflicts in order to protect their liberties, their rights, and, in the cases of governments, their sovereignty.